Hello students, welcome to rapid revision batch for the CS executive exams. So here I will be discussing lesson 16, that is Indian Contract Act or else contract law. Okay, let's see some important topics of the Indian contract, where you can see the important topics in the screen. Follow the concepts. Here you can expect around 10 to 12 marks questions for your exams, and I will be discussing 3 questions here, from some important topics. And also I attached the study material for your next upcoming exam. So that study material contains revision sheet and also some important question and answers for the upcoming exams that you can refer, and also you can share that material to your friends also, and that will be helpful for your upcoming exams. Okay, let's start with the question. Okay students, let's start the question from an important topic, that is offer and invitation to offer. So pause and read the question. Okay, let's see the question. A fashion store owner gave an advertisement. So here Mr. Raman, a fashion store owner, placed an advertisement in a local newspaper, that is grand clearance sale, designers dresses at 70% off, limited stock available, and first come first serve. Okay, now Mrs. Kavita saw the advertisement and rushes to the store. On arrival, she finds a specific designer dress and she wanted to buy that dress. But the thing is, the dress is already been sold out. And now she insists the store owner to sell the dress to her, because she is claiming that on her arrival. So that is the contract, because the store owner already gave the ad in a newspaper, that is the offer, and she accepted the offer. Now she is claiming that once she come to the store, then it will be treated as contract. Now you have to decide this scenario according to the provisions of the Indian Contract Act, whether this scenario becomes a contract or else it is just an invitation to offer. So now you have to come to the conclusion by applying the legal provisions to this scenario. Okay, let's see the legal provision applicable to this concept. Okay, the first thing is section 2 subsection A defines the proposal or else offer. Okay, let's see what is offer. So according to the definition, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or else abstinence, he is said to make a proposal. Now you have to compare this definition with the invitation to offer. Okay, let's see. Offer is a definitive expression of willingness to be bound by specified terms, and invitation means invitation to offer is a preliminary communication to gather or receive offers. So there is a difference. When you are giving the offer, as we discussed in a definition, you are giving the offer to get the consent of the other party. If the other party accepts the consent, then you can make a obligation, or else then it creates the obligation. But invitation to offer is nothing but you are inviting the people to give the offer. So here the offer given as an advertisement in a newspaper will be the general invitation given to the public to accept the offer. Now here, when a customer reaches to the store and they have to make an offer to buy the clothes which is available in the stores, then seller can decide whether to give the dress or not. If it is already been sold out, then seller cannot sell it to the customer. So that is what happened in this case, where Kavita arrived on store. So that is to give the invitation to seller as per the scenario. Now she thinks that the offer given in a newspaper or else advertisement given in a newspaper, that itself is an offer, and she has come to store, that is the acceptance. But the thing is, the assumption of the Kavita is wrong here. Okay, let's analyze the question here. According to Kavita here, she made a contract because she thinks that once she choose the dress, then it is a acceptance. The thing is, it is not actually the acceptance. Now the offer given in the advertisement was the invitation to offer, that is not actually the offer. So now the thing is, the customer should come to the store and they have to make an offer to the seller to buy the dress. Then after that, if the dress is available for the sale, then seller will accept the offer, then it becomes a contract. Now in this scenario, it is vice versa. Now the dress is been already sold to the other customer. Now seller can't sell the specific dress to Kavita. So now seller is helpless here because the goods is already been sold out. Now it is against the provisions of the law. So now you have to give the conclusion, that is Kavita cannot insist the store owner to sell the specific dress. See, that is the conclusion here you have to give in your answer. See, no, Mrs. Kavita's claim is not valid. See, here Mrs. Kavita's claim is not valid because the advertisement was an invitation to offer but not offer itself. Clear? Here the store is under no contractual obligation. So when a store gives an invitation to make offer, then it is not an offer and it does not create any obligation to the store owners or else store. Now in this scenario, Kavita's intention is wrong and it is not the contract. So that is the conclusion to be given in your answer. Okay, let's move to another topic. Second important topic, that is capacity to contract or else contract with the minor. So as you read already, contract with the minor is invalid or else void ab initio, because when you make a contract with the minors, that will be void ab initio, means void from the beginning itself. You can't make a valid contract with the minors. Okay, let's see the question. Okay students, let's see the question. See, according to the scenario, here Mr. Sharma, a major, lent 10,000 rupees to Mr. Amit, who is a minor. And the thing is, at the time of taking the loan, Mr. Amit falsely represented himself as being 19 years old. Okay, note down the point, falsely represented. Okay, continue. Mr. Sharma, relying on these misrepresentation, granted the loan. When Mr. Amit failed to repay the loan, Sharma filed a suit against him to recover the amount, arguing that Mr. Amit committed a fraud by misrepresenting his age. Okay. Now the question is, can Mr. Sharma recover the money from Mr. Amit? Explain the legal position of a minor's agreement and the concept of the restitution under the Indian Contract Act. Now you have to apply the provisions of the Indian Contract Act to this scenario. Okay, let's see what legal provision says about the contract with the minor. See, first you have to go through the section 10. See, here section 10 says that when you are making any contract, a party is to be competent to a contract and they must be of age of majority and of sound mind. So this is a basic condition to make a contract. When you are making any contract with the other party, you have to see the competency of that other party. That party must be a major and also that party must be a sound minded person, or else your contract becomes void ab initio. Here void ab initio means void from the beginning itself. Okay. Next, another section is section 11. It states that a person who has not attained the age of majority, that is 18 years, is incompetent to contract. Then another provision, legal position of a minor's agreement. Now as I said, when you make a contract with the minor, that contract becomes void ab initio or else void from the very beginning itself. And also there is a case similar to the scenario given in the question, that is Mohiri Bibi versus Dharmodas Ghosh. In that case also, a minor falsely represented himself as a major and made a contract and took a loan. So here to make a loan agreement, minor made a contract by misrepresenting his age to the other party. Okay, let's analyze the question. And there is another concept, that is doctrine of estoppel. See what doctrine of estoppel says. Here according to the rule of doctrine of estoppel, here where a person cannot deny a statement they previously made, means if you make any statement, then after that you can't deny the statement. You have to obey the statement and you have to face the consequences or else obligation created by that statement, and you are liable to fulfill that obligations. But that but that one is not applicable in case of minor's agreement. Here minors can plead his minority in any situation. Okay. What about the restitution? So here for the restitution, generally a minor cannot be forced to return or restore the property received under void agreement. So this one is the provision related to the contract with the minor. So now you have to compare it with the available facts in a question. Okay. Now let's make an analysis. Here agreement between Mr. Sharma and Mr. Amit is void ab initio because of the minority of the other party, that is Amit. Here in this case Amit is a minor, so that your contract is void ab initio even though minor committed the fraud. So here in this case also Amit falsely represented his age as major, but by believing that fact, here other party entered into a contract and he gave a loan to the minor. Now Sharma in this case cannot recover the loan amount based on the contract. And regarding the money, if the money is traceable, then you can recover that traceable money. Here you can't claim the compensation against the minor because court will not receive the case filed against the minor because of the void nature of the contract. See, here law protects the minors from such liability even when they act deceitfully. Even though minors commit the fraud, later in a court of law they can plead their minority. That is the immunity available for the minors in a court of law. So in this case also loan given by the creditor is void and the contract itself is a void ab initio because of the incompetency of the party. Okay, let's see the conclusion to be given in this question. Okay, see the conclusion here. Here Mr. Sharma cannot recover his money because the contract with minor is void ab initio. Now minor's misrepresentation of a age does not make the contract valid and enforceable. So this is the conclusion to be given in this question. Okay, let's move to next topic. So that is a revocation of continuing guarantee. So here guarantee is a exceptional cases where even without the consideration also you can make a valid contract related to guarantee or else giving the surety to other party. So usually guarantee is given in case of the loan agreements. Okay, let's see the questions here. See, now the question is, Mr. A provides a continuing guarantee to a bank for all the loans taken by Mr. B up to the limit of rupees 10 lakh. So this is the first fact in the question. Then Mr. B takes a loan of rupees 3 lakh under his guarantee. Then subsequently Mr. A dies. Note down this point. Okay. Now the bank, unaware of Mr. A's death, grants another loan of rupees 2 lakh rupees to Mr. B. So after Mr. A's dismiss, then Mr. B subsequently defaults on both loans. The bank seeks to recover the total outstanding amount of 5 lakh rupees from Mr. A's legal representatives. So these are the facts of the case. Then see what is the question. Analyze the liability of the Mr. A's estate for the loans taken by Mr. B. Determine the amount that the bank can recover from the legal representatives of the Mr. A. Now you have to suggest the bank. So what the available option for this bank in this case? Okay, let's see the legal provisions. Okay, so this is the legal provision applicable to the given scenario. Okay, see, according to the section 129 of the Indian Contract Act, here continuing guarantee means one that extends to a series of transactions. So that is the provision of the section 129, and section 131 says that the death of the surety operates in the absence of any contract to the contrary as revocation to the continuing guarantee, so far as regards future transactions. If a party dies in case of any continuing guarantee, then after that the contract made by the other party will be invalid. So according to the section here, a continuing guarantee revokes after death of the party who gave the continuing guarantee. Okay, let's analyze the question. So here after making first loan, A dies. So after the death of the A, the duty of the bank is not to allot any further loans. But the thing is here, so now here in this case, bank has claimed the compensation against legal heirs, that is estate of the Mr. A. See, the legal representative of Mr. A are therefore only liable for the transaction that took place during the Mr. A's lifetime. So when applying the legal provisions to this scenario, you can clearly understand that once a party dies, then after that he will not have any liability according to the specific contract. So here only 3 lakh should be paid by the legal representative of the party. So here in this case, the first loan of 3 lakh was taken while Mr. A was alive, and his estate remains liable for this amount, and the second loan which is given after the death of the Mr. A, that is invalid, so that here legal heirs don't have any liability to pay the additional loan, that is 2 lakh rupees. Okay, let's see the conclusion for this question. See, here you have to write like this: legal representative of the Mr. A are liable only for the first loan, that is 3 lakh rupees, and not the additional loan 2 lakh rupees. Here bank can recover only 3 lakh rupees from the Mr. A's estate. Clear? So that is the conclusion to be given in your answer. So if you like this video, please do share it with your classmates, and also those who are giving the professional exam, that will be helpful for their exams. And please also note down the materials given in the description, and that will be helpful for your upcoming exams. Thank you, students.